Hello, I'm Janine Turner, founder of Constituting America. Welcome to our annual 90-day study. 90 plus 90 equals 180. History holds the key to the future. This year's study is entitled The Genius of America, A Journey into Our Republic, a study on Alexis De Tocqueville's Democracy in America. This is a quote by Alexis De Tocqueville. The judicial power's political power is so great that it appeared to me that to speak of it in passing would diminish it in the eyes of readers. This essay is entitled On Judicial Power in the United States and Its Action on Political Society, Volume 1, Part 1, Chapter 6 of Democracy in America, by Alexis De Tocqueville. Guest essayist, Kevin Gutzman. Alexis De Tocqueville entitles Volume 1, Part 1, Chapter 6 of Democracy in America, quote, On Judicial Power in the United States and Its Action on Political Society, end quote. He attempts to describe American judicial institutions as if they were all of one model, along the way comparing them to the French courts more familiar to him and to his intended readers. Particularly notable to de Tocqueville as a foreign observer was the political role of American courts that we Americans have come to take for granted. Quote, The judicial power's political power is so great, he explains, that it appeared to me that to speak of it in passing would diminish it in the eyes of readers, end quote. Federal, Republican, and elective governments are not peculiar to America, this Frenchman notes, but the American judiciary is unique. Its weight is felt in every political discussion. In regard to particular cases, it exercises its power as other countries' judiciaries do, quote, as an arbiter, end quote, between parties, or, quote, on particular cases and not on general principles, end quote, parentheses, that is, not on an advisory or legislative basis, end of parentheses, and, quote, only when it is appealed to, end quote, parentheses, that is, when a case is properly brought before it, end of parentheses. Yet American judges, de Tocqueville insists, have political power of a remarkable kind. Quote, Americans have recognized in judges the right to found their rulings on the Constitution rather than on the laws, end quote. What he has in mind is that American judges exercise the power of judicial review, which he classifies as political, not legal. To an American, this distinction is jarring. We have all been indoctrinated in the idea captured in Article 6 of the United States Constitution and forcefully said to have been the bedrock of judicial review by Chief Justice John Marshall in Marbury v. Madison. That judicial review is precisely a legal function. That what is happening when a judge says a statute is to be inoperative, struck down, on the basis of unconstitutionality, is that inferior law is being made to yield to superior law. As Marshall put it, quote, it is emphatically the duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret the rule. If two laws conflict with each other, the court must decide on the operation of each. If courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case to which they both apply, end quote. It was by political acts that the sovereign states, following the Article 7th ratification process, put the United States Constitution into effect. Yes, but determining whether a law is constitutional in a case brought before it by one of the parties is for an American court a legal task, not a political one. De Tocqueville essentially concedes this point without making it when he notes that in America the people can, when they so desire, change a constitution, state or federal. After comparing the relationship between law and constitution in the American system to the relationships between law and constitution in France and in Britain, de Tocqueville asserts that there is little to fear from judicial decisions holding laws unconstitutional, as they will only affect the particular cases the judges are deciding. Whether a statute will be repealed because unconstitutional is a question that will only be decided after several related cases have been adjudicated. Here, our author is simply mistaken. Decisions holding statutes unconstitutional have commonly had immediate and general effect since American courts first exercised the power of judicial review. De Tocqueville next asserts that judges exercise the power of judicial review only despite themselves. They have no impulse to do so, he says. We are familiar with numerous instances in which Americans certainly were, or at least seem to have been, anxious to exercise the power of judicial review. At least one of them, the Supreme Court case of McCulloch v. Maryland, 1819, ought to have been known to de Tocqueville. There had already been numerous cases of judicial review in federal courts by the 1830s, when de Tocqueville wrote his book, and they have come to be quite numerous now. De Tocqueville closes this chapter with consideration of Article 75 of the French Constitution of Year 8, 1799, which made Napoleon Bonaparte first consul. Under that constitution, he says, a government official could only be tried after the Council of State had decided he could. American courts have no need for such permission, he notes. This essay was written by Kevin R.C. Gutzman, J.D., Ph.D., is professor and former chairman of the Department of History, Philosophy, and World Perspectives at Western Connecticut State University. He is the author of 6 books in the history of the American Revolution and early republic, one of which was a New York Times bestseller, 2 of which were book club main selections, and one of which was named one of the 10 outstanding conservative books of 2007. His latest is The Jeffersonians, the Visionary Presidencies of Jefferson, Madison, and Monroe.